Hello, and welcome to the Break from the Bench series, hosted by the National Council of Juvenile and Family Court Judges. Welcome our presenters for today, starting with Loretta Frederick.
Yes, I'm with the Battered Women's Justice Project. It's a national resource center on the legal system's response to gender-based violence, and been there many, many years and serve on the faculty of the National Judicial Institute on Domestic Violence. That is the council's effort.
And I'm Marshall Murray. I'm a judge in Milwaukee, and I have sat in the children's court, family court, probate court, criminal court. We have a specialty domestic violence courts in Milwaukee County, and I've been on faculty with the National Council and faculty with Futures Without Violence for a number of years. So I'm glad to be here with my good friends Loretta and Darren.
Hi, everyone. My name is Darren Mitchell. I'm an attorney and I'm a consultant to several national domestic violence organizations, including the National Council, who's presenting this program. I've been doing work in this area around family law and family courts' responses to domestic violence through protection orders and custody decision-making, and also looking at how courts and systems respond to firearms in domestic violence cases. Now it's been 20 years, and I too have joined Marshall and Loretta and others at the NJIDV sessions. So thanks so much for being with us this afternoon. And I'm going to start things off by asking my friend Loretta. So from your perspective, what is coercive control?
Well, it is one form of intimate partner violence or domestic violence, depending on the language you want to use. We have known for many, many years, and in fact, judges are some of the people most familiar with this distinction, that there are a lot of different ways that intimate partner violence can show up in families, with couples and so forth. And for example, there are some cases of violence between intimate partners that are solely rooted in problems like mental health, chemical dependency, and other forms of motivation for violence. And we know that the use of intimate partner violence can vary in the purpose the violence serves in the relationship. Also, it can vary in terms of the effect of the violence on the family members, on the children, on other people related to that relationship. And also, it can vary widely in what message the survivor of the violence, the victim of the violence, takes from it. So what's being communicated by the violence, by the abuser to the survivor of it. So these are kind of critical areas that lead us to understand there are many different contexts within which intimate partner violence or domestic violence, depending on what you want to call it, can show up. Coercive, controlling, and abuse is one of the contexts for an act. So what we're talking about here today is that whereas you might, as a judicial officer, learn about an act of violence in a relationship, what we are talking about today is one of the contexts within which an act of violence can occur. And before we get too far into this, we would like to remind you that a lot of what is coercive, controlling, abuse may not look like very serious violence. So it might look like just low-level physical abuse of no consequence. But what we're talking about today is the larger environment of the relationship and the connection between the action the abuser is taking and what effect it has. So, so coercive, controlling, abuse being one of the contexts within which violence can be occurring is basically a kind of violence that is patterned. That is, it is never just an incident, as I mentioned before, and that it's a combination of physically threatening or physically harming behaviors, so violence, and it also has a feature that it is about intimidating the victim of this kind of violence into being dominated and controlled by the abuser. So
So,
it is, yeah.
So Loretta, I didn't mean to interrupt you, but I think there's two things that you said, which is very important for the folks to know about. Is that incident-based. Unlike a criminal case where an incident happens, the prosecutor looks at it and says, I can prosecute based on this incident alone. There's enough for me to charge the case, prosecute the case, go forward. And what you're talking about is more of a big picture, more than just the incident that occurs, but why something occurred, the intent of the person who committed the violence. So I want to point that out to our listeners, that we're focusing on the intent of the actor and is in context of what else they do with that in that relationship. Yeah,
and we're not, and it's obvious as you're giving an example of when the court is dealing with a domestic violence case, it could be in many different contexts, right? The criminal case that's about an incident, whether the elements of the crime have been proven and so forth. It can be in the context of a protection order proceeding where you're deciding whether domestic abuse as defined by your state law, your jurisdiction, has occurred or not, which would allow you the order granting XYZ relief. What you're talking about, Marshall, is the fact that no matter whether our job on the bench is about deciding guilt or innocence, deciding whether protection order should enter, deciding whether child custody, domestic violence related presumption in the law has been triggered and so forth.
Make sure it's muted.
But also that when we're deciding what kind of relief to grant, we're considering the entire picture of the relationship, not just that incident, because an incident can be very minor, but it may be in the context of an extremely dangerous overall situation. This is why this kind of contextual approach to looking at the what's going on behind the incident is absolutely critical. So we can be responsive to what's really happening and not just responsive to an incident, which may reflect not at all the seriousness of the overall situation, right?
Yeah.
Darren, you're muted. Yeah.
Thank you, Loretta. I wanted to step in for a second because I know you've talked about part of what judicial officers and others need to be aware of is that sometimes situations in which there is just sort of lower level physical abuse or threats of physical abuse, but this controlling behavior that's happening. And I know that judicial officers and others can struggle sometimes with the difference between coercive control, as you've described it, and kind of being controlling. Because I bet that most of us can think of instances in which we've been controlling kind of in gentler ways than what you're talking about here. And actually, I bet that likely all of us can remember a time when our partner has been controlling of us in a sort of a gentler way. So it's important to recognize that what we're looking at here is a situation that's those sort of gentler forms of it. There's no implicit or explicit threat under those situations of harm, whether it's physical harm, severe psychological harm, or other things that really gives the actor power and threatens punishment if you don't comply. And as we'll talk about, one of the hallmarks of coercive control is setting rules and enforcing those rules. So one of the things to be looking at in case, because people are accusing each other of being controlling or of pointing particular instances, particular snapshots in time, one incident, and saying, she's very controlling, he's very controlling. And as a result, I can't, I've lost autonomy. It's not a good parent for that reason, whatever. There's a big difference between that kind of, I want to make sure that you're dressed a particular way because I want you to look nice when we go out to dinner, versus if you don't wear those heels, if you don't wear heels, or if you don't wear the outfit that I think you should wear, you're going to be punished for it, whether it's physically or otherwise.
Exactly. And one of the things that's frequently seen in coercive controlling abuse cases is over time, a decreasing amount of autonomy the survivor has. So if over time you're continually, and sometimes in gradually increasing ways that are kind of sneaky, the survivor may find themselves at a loss of control over their own thinking, their own actions of many kinds, not only what you can wear, but when you're going to be home, how much money you have access to, whether you're allowed to parent children in a way that you deem appropriate, whether you can get medical care. And under the pandemic conditions, these controlling behaviors are really effective, because an abuser under these conditions has a lot more tools available to them to control, intimidate, and sort of through establishing a climate of fear, really manipulate what is going on in the family, including the children whose exposure to this kind of abuse can be really, really damaging, can teach them very bizarre things about what it is to be in a relationship, and can also terrify them as they see the lengths to which one of their parents will go to control the other person. Yeah.
So you mentioned the intent. You both mentioned the sort of the intent and motivation pieces being so critical, and it's worthwhile to spend just a couple of minutes here to consider what coercively controlling abusers derive, the benefits they derive from their behaviors. And thanks to the work of Chuck Derry in Minnesota with the Gender Violence Institute, who's worked with batterers for many, many years, and has collected some of their own thoughts and observations about what being this kind of abuser means for them, what their benefits are. So we have a short clip that we're going to show you with those statements, some of those observations and statements. Benefits of violence and abuser's perspective. Keeps relationship going. She's too scared to leave. Decide how money is spent. You get to do that as the abuser. I get to decide her social life, what she wears, so you can keep your image by how she acts. I can keep my image. You can use kids to spy on mom. You can convince her she's the problem, that she's unattractive, that she's to blame for whatever problems the family has, to gaslight her, things like that. Make the rules. You get to break them when you want, but you're going to comply. You're going to enforce compliance with the rules by the victim. So those were actual quotes from abusers describing why they undertook a course of conduct along the lines of what we've been talking about today.
Darren, can I add something else? Oh, Marshall, go ahead.
Yeah, I was just going to say, if you notice those quotes, they all focus on what the abuser gets, what they get out of it, not what the other person doesn't benefit from it at all. And I've had the opportunity to work with abusers and have learned from them as well that, a lot of the things that they are doing are things that they've learned from their fathers or their caregivers. And they're just kind of mimicking the behavior because they think it's beneficial to them, not to the person that they are abusing. There's no benefit at all.
Mm-hmm. Yeah, and there's a couple more things I want to add to this before we move on. One is that remember I was talking about how there are different contexts within which abuse can show up. One of the contexts is the violence that is frequently used by the victims of this type of abuse against their abusers. So one of the responses that's not unusual for a victim of this kind of violence is to fight back, and to even use behaviors that are criminal, where self-defense might not even be operating principle. So there can be, you may have somebody before you who has been using violence against their partner, and the context for that person's use of violence is their violence is shaped by, created by, and in direct response to this type of violence against the perpetrator you're looking at. And so a different response entirely is warranted, because the intent and the meaning and the effect of that violence is radically different from what we're talking about here. And I think the bottom line is we have to remember that coercive controlling abuse is qualitatively different. It isn't just, it's not simply one end of a severity spectrum or anything. It's just a different thing entirely. And its a critical feature, its distinguishing hallmark is that the victim is placed in an objective state of entrapment. That is to say, their freedom and autonomy is limited in some significant ways, which in order to respond to it, we have to know about. And the third point is, it's not just psychological abuse. It combines with how kind of our culture is structured to entrap a person and limit their options and their freedom to leave the relationship, to be who they really are, and so forth. And making this more difficult is the fact that you can't just administer a diagnostic test to determine whether a person is a coercive controlling abuser. And so it's up to us to provide to the court, practitioners to provide to the court enough information, and for the court to get enough information to be able to realize this is what's going on, and then structure relief that will meet the challenges.
Yeah, even though there's no kind of questionnaire that we could give to the folks that are hearing these cases, the questions that would pull all this out, it is important, I think, for judges to begin to recognize the difference between controlling behavior and other sorts of violence, because if we don't, it leads us to the wrong interventions. We make the wrong decisions. We don't have an impact on those relationships, that the kind of impact that we could have if we had just asked the litigants to give us the information that we need. Even though and judges will tell me, well, I'm not an investigator, I'm not a social worker. Not asking them to be a social worker, wouldn't ever suggest it. It's a hard job being a social worker, but it's important for us to get the right information so that we can make the best decision possible.
So, yeah, so you're implying that it matters whether a judge understands this concept of coercive control and gets enough information to determine what's going on. So can you talk more about why it's important for judges to understand this sort of abuse?
Well, I think it's important if you understand the abuse and why it's happening, it helps you to understand the abuser. That's the person who's in front of you, most likely either seeking, is someone seeking some action against them, or they may be in court seeking you to complete some action against the other person. One thing that's important to know is that controllers understand rulemaking.
Oh.
Yeah, they understand rulemaking, Loretta, and they, when they're in court, they think that they can still make the rules, and we allow them. They will violate our court orders. They will do what they can to obstruct justice. They'll manipulate us in our courtrooms, and manipulate the other professionals that we've asked to look at a case, whether it's a mediator, whether it's a guardian ad litem, whether it's the lawyers, to say, look at this case, tell us what's going on. They will try to manipulate the situation, and they will even go as far as to intimidate witnesses that may come in and testify against them. The important thing that about the controllers are, and I think Darren kind of pointed this out, they want something for themselves. And when they can't get that anymore, that's when they really become dangerous. When they can't have that control anymore, when they lose that control. I would see it in my courtroom sometimes where I would identify someone as being a controller and would let them know that I have identified them as being a controller. And this is more about their ability to control the other person than about getting justice. There's a difference. And their violence will continue, is evidenced by, if you look at cases, their violence will continue even after the relationship is ended. And by the way, I think it's important, Loretta, when you think it's important to say that, it's just not gender-based. It could be someone in a same-sex relationship, but it's the behavior that you're looking at, not necessarily the gender all the time.
I wanted to just shift the focus a little bit. I think, Marshall, you did a great job of helping us understand this from the perspective of the person who's using this form of violence, to shift and think a little bit about the impact. And you've touched on one piece, which is this idea that the threat can continue post-separation. And in fact, the research does show Dr. Jacqueline Campbell of Johns Hopkins University, who's done the most extensive research into dangerousness factors, has seen in her research that that this sort of entrapment that we've been discussing, these forms of coercive control in a relationship, is an indicator that post the relationship, there's much elevated, a great deal of elevated risk of severe abuse and even homicide in those cases. So that's one very important reason to care about it as judges. The other piece is to recognize that when coercive controlling abuse is present, the research shows that children's exposure to that form of abuse, this pervasive coercive control that we're talking about, can really have devastating and long-term consequences for kids, developmentally, behaviorally, cognitively, along all the different dimensions that we see. And so exposure to coercive control, even if the child is not the direct target of the coercive control, has such an important long-term impact that it's really incumbent upon all of us, including judicial officers, to do what you can to detect it and address it and tailor your rulings in whatever case you're involved in, as Loretta said earlier, to address that particular form of coercive control.
Mm-hmm.
And Darren, thank you for raising the issue of children, as you always do. You always look out for them, and I appreciate that. The reason that we are trying to focus on this in this conversation, I'm glad that I could have this conversation with both of you today, is that this sort of behavior rears its head in a lot of different courts. It could be in children's court, where I see juveniles that are coming in, they're acting certain ways, they're doing certain things, and we're trying to figure out what the genesis of that behavior is. We see these folks, these families in family court. And I've seen them in probate court, frankly, where we have elder folks who need services, and they may be suffering from or under an abusive hand in their own home. And we clearly see them in the criminal courts. So being able to recognize it, being able to see it, and know that if it looks like a duck and walks like a duck, it probably is a duck. That's going to be helpful to us as judicial officers in trying to make the best, as I come back to make the best decision possible. Because at the end of the day, if something goes south, people are going to look to us and say, why did you make that decision? Why didn't you do something?
Mm-hmm. Yeah, one of the, so you're talking about using it in juvenile court and family court and so forth, these concepts, and looking for the problems that can arise from coercive control in those kinds of settings. And someone chatted in to ask about specifically, what does this kind of look like in the child custody and family court cases? And I can just say that all three of us have been working for several years on trying to figure out how to equip the family court to uncover this kind of thing because coercive controlling abusers, as you might imagine from how we've been describing them, think about themselves as having the right and being entitled to control their family members. And going so far, as Darren mentioned, to enforce their will, as to use violence and threats of violence and intimidation and this sort of ongoing creation of this environment of fear. And that, as you might imagine, can be quite inconsistent with good parenting. And we know that, as Marshall said, this sort of behavior, this way of thinking, is pretty central to how these abusers view the world. And so just separating from the other parent, or just dividing up time that the parents have with the children, and even dividing up decision making, is not, that doesn't address the underlying thinking of the coercive controlling abuser, is an inadequate response to the problem in the family court. So the challenge that I think that we have in the family court is to structure decision making, structure the sort of parenting arrangements and so forth in a way that actually accounts for the behavior and the thinking and the attitudes and the beliefs and the parenting behaviors of a coercive controlling abuser. It's really, it's a much more complicated thing than a non-coercive controlling abuser case is, because you don't have two parents who are relatively decent. It's a matter of figuring out, practically speaking, where the children should be when, and whether they can share decision making and all that kind of thing. It's a different animal altogether. And we've got some tools in our office for getting underneath this in a more detailed way, like what is the connection between coercive controlling abusers thinking and behavior and their parenting capacity, their ability to co-parent, that kind of thing. So yeah, it has, as the questioner is suggesting, big implications for parenting in the family court context.
Loretta, I just spent about a couple of weeks ago an afternoon with a group of guardian ad litems. And it came to me with the same question that you just raised, and the same concern that was raised by the person on this call today. One of the hardest concepts is moving away from the idea, or letting go of the idea of co-parenting, when one of the parties is about controlling the other party. That's their focus. Their focus is not on parenting. And one of my arguments that I made to guardian ad litems, you should be ready to figure out what's going on in this relationship between these two people, and to determine whether or not they're able to parent the children. So if I'm the abuser, and I'm focused on getting what I want, it has nothing to do with the children and what they need. And so they may not be able to parent their children, and therefore they may not deserve to have custody and placement until they change their behavior and their thinking. So this concept of being able to understand or coercive controlling is to understand, which I've learned from you and from others, and like Darren, is that if you have that personality and that's what's going on, you're not thinking about the children. You're thinking about something else. You're thinking about yourself and what you can get.
Mm-hmm. So do you think we should talk some more about what examples we have seen in our work in the court system generally of coercive controlling abusers? Like, how does this show up in our case law? Yeah.
And I can start that
think I'd like to hear from, I think, Darren, can you help us out here? Why should judges care about this, and what examples do you have?
Well, the examples that I can share are, from many different contexts. As you know, we've been talking about coercive control having several kind of domains. And includes dominant acts of domination, acts of intimidation, of isolation. There's this idea of kind of the micro-regulation of daily activities, which is one of the terms that one of the sort of early researchers in this area, Evan Stark, came up with in terms of this pervasive, always in your business kind of dominance, where the individual feels like they're, even when the abuser is not present, that they are present in some way, they're monitoring what's happening, and other behaviors. We've seen examples of all of those in our work, and I'm sure you have as well. So we have abusers who may have been physically abusive once in the past, but will remind the victim either explicitly or through kind of implicit clues and hints of what they're capable of, while they set and enforce these rules that we're talking about, like you can't buy any toys for the kids without my permission. You're not buying a new crib. I need to be the one who's, I'm the one who's responsible for that. You need to stop visiting your best friend. She's trying to drive a wedge between us. You need to show me your texts. I want access to your email. I want to see who you're talking to. And this kind of using electronic means of spying on and monitoring the actions of victims. Stalking, essentially. Stalking is part of coercive controlling conduct and sort of on the monitoring phase of what's happening in the microregulation. One of the challenges for judges and for everyone in the system is that sometimes these kinds of behaviors are difficult to detect, and they appear innocuous. They seem like something that's not a big deal. So in those kind of electronic monitoring things I'm talking about, like installing a GPS device on a car or a keystroke monitor on a computer, which we've seen done, no one even knows what they're doing at that point. The victim herself may not know and may not find out until kind of later in the relationship or even in the course of litigation we've seen. So those are very difficult to detect. But in addition to that, this idea of kind of seemingly innocuous or loving behavior that is actually a message being sent to further the coercive control, like giving the victim or a child a stuffed dog after the abuser has seriously injured or killed a family pet, is something that we've seen. Or the abusive partner who shows up at work regularly. And everyone in the office thinks, oh, what a great guy. He really cares about her. He's coming by, he's bringing her flowers, he's bringing her lunch. When in fact, she can tell you that what he's doing is keeping tabs on what's going on and letting her know that he's ever present and can find out quickly what she's up to. So again, very difficult to detect without having this broader picture that Loretta's tools and asking the right questions can help you to develop. I just want to touch on very briefly the COVID, the pandemic related stuff. Loretta discussed it, and I believe that Jennifer chatted in the link to some of the COVID materials that Loretta and her colleagues at Battered Women's Justice Project have put together. It's critical at this stage, and we know we're going to be in this position for a while now, to be thinking about what the pandemic means in terms of furthering coercive control. And we've seen so many examples, like refusing a victim to go to work, not allowing her to go to work, saying it's too dangerous. It's too risky as a means of control. This is like a perfect opportunity to exert that kind of control, including financial control and limiting the autonomy and the ability of a victim who may want to leave. Refusing access to the family's computer. There may be one computer, everyone's stuck at home, kids got to do their work, both parents may be working. We've seen that for sure during stay-at-home order time. Refusing to return kids from visits. So even post-separation, we see this where an abuser says, your job is too risky, you're potentially exposed to the virus.
So we have first bigger number.
And things like that mean that I can't give you back the child right now. And of course, as many of you know, getting recourse from the courts right now can be difficult to impossible in some circumstances, and getting emergency orders to modify and address these situations can be very difficult. So, but I'm curious, Marshall, as a judge, what stood out for you in terms of coercive control that you've seen in your work?
Well, what I would see, at least in the courtroom, is situations where, as I stated before, the person who's really about controlling others is that they wanted to control me as well. They wanted to control what happened in the courtroom. They wanted to control the process. I had a gentleman one time, and it was no physical abuse, but it was a divorce that was happening, and the person was explaining how about this person's behavior and how they would try to control the situation. And I had a sense that that's what was going on in the case, but I wasn't sure. But so regarding custody and placement of the child, I had separated custody and placement of the child between the two parties. I gave them joint custody and placement with visitation hours and stuff. And the father could not follow the rules. He didn't want to follow the rules. He would go pick up the child and said, let's go get some ice cream. Of course, the mother couldn't say you can't have any ice cream because that would make her look like the bad person. And so when he came into my courtroom and I said, I gave you specific time and place that you could have custody of your child, enjoy your child, and I asked you to do that, but you couldn't do it. And he looked at me, there was silence for a moment, and he said to me, Judge, I guess you and I have a different God. And that just emphasized to me that this person is not able to hear me, to follow the rules, and therefore he shouldn't have custody or placement of his child until he could figure some other things out. Because I had never brought God into the conversation. And other men and other people would bring that that kind of behavior into the courtroom where they're trying to control me and let me know that I'm messing their thing up. I'm messing whatever they had going on, you're interfering with that. So those are the kind of things that I might see or that I would see in my courtroom.
And Darren, can I add one more example of how this can show up in our systems? We rely heavily in the family court system anyway these days, and sometimes in the juvenile court system, on mediation or other kinds of facilitated dispute resolution processes. As you might imagine, these kinds of abusers might very well be unwilling to actually engage in the sort of respectful give and take, interest-based process that mediation and other kind of processes like that require of people. And we've had a lot of examples around the country for decades now, frankly, of folks ending up in mediation where the survivor of abuse is intimidated into going into the process because they understand the judge wants them to settle the case, and their lawyer may be even telling them, if they have a lawyer, maybe telling them you have to do this. So they feel compelled to engage in the process, and then they get into the process and they feel beaten into, in a literal or figurative sense, making a deal that they know is not in the interest of their children. It may not even be safe for them. So we have to, as a bunch of family court people anyway, get much better at ensuring that survivors are making informed choices about what dispute resolution process would result in a safe, outcome for their children and be a process they can endure and benefit from. So that's another example, I think, of how things show up. But
so, Loretta, I have a question for you. So I work in this system. I'm a part of the judicial system. I'm trying to hold people accountable for their behaviors. I'm trying to intervene. I want to intervene appropriately so that we use the right resources so that people can change their behaviors. What are the things that the system can do to respond to enhance safety and promote appropriate accountability? What can we do better?
Yeah, thank you. And I think this is one of the things that a couple of people have chatted in to say, like, so how do I know this is going on? And because, if I care and I want to really intervene in these families in a way that's useful and effective, it's not overprotective, it's not underprotective. And one of the answers to this, I think, is that the bench is in a particularly powerful, shall I say, position in a community, in the sense that judicial officers can express the expectation of practitioners of all kinds, guardians, lawyers, custody evaluators, mediators, folks who work with self-represented litigants, advocates, and so forth. So a judicial officer can say, I need the kind of in-depth, contextual information about the abuse in this case that will allow me to structure a parenting arrangement, to decide a pretrial release, bail condition, order, sentence someone for a crime related to domestic violence, issue a protection order with the terms that would be, in fact, useful and protective. Those are the kinds of things that one can do only if one really has this good contextual information. So Jennifer has chatted in a link to the materials that the Battered Women's Justice Project has been designing over the last decade. And this is an approach called SAFER, S-A-F-E-R. It stands for screen, assess the nature and the context of the violence, focus on the effects, and respond. And we have a whole bunch of worksheets and guides and other things that can help practitioners pull together the kind of contextual information that the judges need to make decisions in these cases. We do a lot of training around the country, and we've had a couple of court systems that are trying to encourage all the people working in the courts, in the family court context especially, to gather and provide this kind of information into the system. So that's one thing I would recommend.
Could I just add something quickly to that, Loretta?
Mm-hmm.
And I've had the pleasure of working with Loretta on this and training on these materials. And one of the things that I think is really helpful is to recognize that it's kind of a self-reinforcing thing. At this point, people may not be raising these issues with judges in any of these kinds of cases because they think that it's not really going to help them. And it could be risky for the victim too in many ways. So it's kind of a self-reinforcing thing when judicial officers say, I want this information, and then they act on it. The stakeholders who come before you and those who work with victims in the system earlier on, before any of this information gets to you at all, will recognize that it is something that the court wants and is important to decision-making, and will do it. So this system-wide approach to it, I highly encourage. I mean, the judges who are on this call are, by virtue of you participating with us here, are leaders, and you're leaders in your community. And so one of the things to think about, if you have any interest in these approaches or the resources that Loretta has described, is to bring them to your community and share them and come together and talk about how the response to coercive controlling abuse in family law cases can be improved, because we've seen in a few places that it's really made a huge difference.
Yeah, I would agree with Darren that if our legal partners, those who share the courtroom with us, understand why you need this information, they will make sure that you have it. And even the pro se litigants, if you ask the questions in a right way, not an accusatory way, you can get information from them. I had a young lady who wanted a protection order, and I'm trying to figure out what the relationship is about. And I asked her directly, I said, and so what are you worried about if I don't issue this protective order? What do you want to know? And she was very clear with me. I'm not worried about him doing anything to me. I'm not afraid of him. I just want him to know that he better not act this way in the house again. And so it was clear that whatever intent he had, it didn't have an impact on her when she was worried about this guy going off and her harming her in any way. So it gave me a different picture of him based on that one question that I asked of her. And she was very open about it. She got the injunction for a short period of time because she wanted to send that message to him about his behavior, but she wasn't worried about him eventually getting to a point where he might cause her serious bodily harm or even kill her.
So I know we only have a couple of minutes left, according to my clock. There were a couple of questions and observations about how difficult it can be where so much of this is hidden. Abusers appear to follow the rules publicly, but we know other things are going on behind the back. Plus statutes are not necessarily receptive to coercive control. I was just wondering if maybe we can close by saying a word or two about overcoming those really significant obstacles. Do you guys have thoughts?
Yeah, I think one of the things, first of all, yes, the legal system is structured around laws and definitions of abuse and what's included and not included. And I think the trick is in the absence of change in statutory definitions and so forth, I think the solution is to be able to give as much detail to the court as possible to help the court understand the true nature of the abuse. In fact, even there are a lot of courts that are improving the way their SRL system, that is, you know, the people in the self-help center or the people at the court administrator's office that help folks fill out forms, the people in the local law library, wherever it is that SRLs are getting help, can encourage in very concrete ways litigants to explain the behavior of the abuser and the effect that it's been having, so that a court can see more clearly whether coercive control or other kind of permutations of abuse are going on. In the short run, that's, I don't know, Darren or Marcia, what you think about that.
I mean, I agree. And I think we often talk about behaviors and not labels. So calling something coercive control or even calling it intimate partner violence or domestic violence may or may not be helpful. But understanding the behaviors and their impact, as you've just laid out, I think is the key. And in the family court context is for all of us to start to understand better how those best interest factors that the court has to hang its hat on for the decision making, how each of those factors is affected by this form of coercive control, these kinds of behaviors. What does that mean for your analysis of those best interest factors is one way to be thinking about moving forward on this.
Yeah, I think that the system is doing a better job of intervening in these situations. I think just by the mere fact the people that are on this call today tells me that we have people, as you pointed out, Darren, who are leaders and want to be leaders in this area. This is not something that's new to our community. This is something that is happening all the time, and during these COVID times, maybe even getting worse. But if we intervene the right way, frankly, we can help out the whole family. We can even help out the abusers. I don't give up on the abusers. I just want to make sure I get the right intervention so that we can help them to change their behavior, modify their behavior so that they can be good parents, so that if they are in a relationship, they can be a good partner and a safe partner. And that in the fathers that I worked with when I did working with the Caring Dads program, a program out of Canada, the whole focus was to get them to understand how their behavior impacted their children and what had happened to them. So that the trauma that they experienced, they did not want their children to experience. And that's a way to connect with abusers, is through their children about what happened to you can happen to them if you continue down this road.
Well, that seems like a great note for us to end on. Would you agree? And I'll start by saying thank you so much for spending the time with us.
Yeah.
Yes, thank you so much.
Great conversation.